Welcome all to the CLE program on information and compliance on legal issues for galleries. My name is Minelli Manoukian. I'm the Executive Director of the Center for Art Law. We are so excited to have you all here. A quick note of thanks to our co-host, Wilson Elser, and also to, especially to Jana Farmer, who helped organize this event, and Tess, who will be our moderator for the event. Both of these individuals are advisors on the Center for Art Law's Advisory Board, and we are more than excited to host this event. A quick word about the Center for Art Law. For those of you that are unfamiliar with our work, the Center for Art Law is a Brooklyn-based education and research nonprofit focused on bridging the gap between the art world and the legal profession through our newsletter, our programs, and the millions of other things that we do. We try to keep our audience updated on everything that is in the intersection of art and law. We hope that you enjoy this program, and if this is your first time joining us, welcome. We're so happy to always see new faces. Quick note here, for archival purposes, this program is being recorded. If you don't want your video on, please feel free to turn it off, but we do like seeing your faces if we can. Quick thank you to all the premium members of the Center for Art Law that are going to be present today. The center couldn't be what it is today without the support of hundreds of art law fans. So we are so grateful to have you there. If you're interested in receiving free or extremely discounted access to the Center for Art Law's programming for the future, please consider becoming a premium member. You can find more information on our website, www.artlaw.org. The center does have a couple other very exciting events that are going to be coming up in the near future. We have a series with the National Arts Club that's going to be focused on around art clinics. So one on artist legacy and estate planning, the other on our new clinic concept for contracts, consignments, and agreements and negotiation for artist-dealer relationships. We also have events on de-essential coming up, and listed today is the event that we have. This is a timed agenda for everybody. This will be our general scope of events. We'll be starting off here and going through our introductions. We'll begin with a primer on privacy issues, move on to ADA compliance, IP issues in the online sphere, and then a moderated discussion. There will be a CLE code that will pop up at some point in time during the presentation. If you are attempting to receive CLE credit for this program, please keep note of that. There will be a poll question that pops up towards the end to show your active participation. You will have to choose the correct code. The CLE credit for this program is currently pending for Wilson Elser, but we will, if you fill out the code, we will get you what you need when we can. Our panel is filled with a bunch of fantastically talented individuals, but I will take this moment first to introduce Tess, who is our moderator for today's event. She's been kind enough to lead the discussion. I will pass the chat on to her. Tess, take it away.
Hi, Minelli. Thank you so much for that introduction. And hello, everyone. I'm so glad you're joining us today. I want to thank the center and our panelists for all of their hard work to put this event together. As Minelli said, my name is Tess, and I'm an IP technology and privacy specialist at Morrison Cohen. And among lots of other things, my firm helps our clients buy and sell their companies. And this process often includes my team's review of the company's websites for the IP featured, accessibility features, and data collection through the website. So I'm really excited to be here today to really delve into these issues with our panelists. So let's start with Jana Farmer. Jana is a partner at Wilson Elser's Intellectual Property and Technology practice. She chairs the art law sub-practice there, and she regularly advises clients on consumer privacy compliance and website accessibility issues, including advising clients on policies and defensive claims. We're also lucky to have Lawrence Shaw here. Lawrence is the founder of AAAtraq, a compliance management system aimed at facilitating compliance with website accessibility standards. And Lawrence has been integrally involved in drafting EU compliance regulations across 5 countries, and he also provides regulatory and risk management consulting services. A key goal for Lawrence is to help organizations understand the value of compliance automation and how it can protect their brand's reputation. And finally, we have Irina Tarsis. In addition to being the founder of the Center for Art Law, Irina is an art historian and an attorney specializing in art and cultural heritage law, as well as nonprofit governance issues. She publishes and consults on a wide range of intellectual property and art law issues, including copyright infringement and fair use, artist rights, restitution, authenticity, and provenance research. So we're very lucky to have each of them here today to help us explore this ever-expanding field of legal obligations for art businesses and galleries as they move their businesses more into the digital world. So without further ado, Jana, could you please start us off with some privacy considerations?
You did. Okay. Good afternoon. Thank you, Tess, for the introduction, and it is a pleasure to be here with all of you today. Let me share my screen. All right. Are you able to see my screen? Okay. So while businesses in general and art businesses in particular have had online presence since before COVID, the pandemic has accelerated a lot of businesses going digital and transferring a substantial portion of their work online. So here you can see some statistics, especially in the first quarter of 2021. Businesses have developed websites, more so in the last few years. They have collaborated with content creators and began collecting personal information on their consumers. So what we want to talk about to you today are some of the issues to be aware of when doing business online. Most of the concepts that we will be discussing today are not new, but how they apply to the online world is one of the challenges. When we operate in the real world, we are familiar with contracts, licenses, model releases, etc. But how do they apply to digital world? So one of the aspects we're going to talk about today is privacy. So in the early days of the internet, people freely shared information about themselves. Then we saw some of the headlines where turns out information may be used for unintended purposes of us, consumers and customers, and maybe even for nefarious purposes. We've certainly seen those headlines also. So nowadays, people want to control information about themselves. They want to know what businesses know about them, and they might even want to get that information back. So in Europe, a few years ago, General Data Protection Regulation, GDPR, was adopted, and it is still probably the most comprehensive policy, privacy law in the universe. And it even applies to American companies under certain circumstances. In fact, we all see the effect of GDPR when we open most websites and we see cookie banners, and you have all of those choices that you need to make before you can enjoy the website. So what I'd like to discuss with you today is what are we doing in the US that is similar to GDPR. So in America right now, we do not have a comprehensive federal legislation. We do have some industry-specific laws, such as HIPAA in the medical space. You have Children's Online Privacy Act. You have GLBA for financial industry, but nothing like GDPR on a federal level. So the states have taken up the banner, and this is actually a very important year for consumer privacy laws, because as you can see on the screen, we have 4 new consumer privacy laws coming into effect next year. And this is the time for those businesses who will be obligated to comply with these laws to prepare, because it's not something that you can just switch on and you are compliant. There's a lot of work that needs to be done in order to prepare. So the 4 states that we currently have privacy laws are California, Colorado, Virginia, and Utah. And you can notice that California Consumer Privacy Act is actually already in effect, and it's already being enforced by the California Attorney General, and there are a lot of obligations that the companies have to already have in place now. So to which businesses do these privacy laws actually apply? So I won't read the chart for you. You're able to read it yourself. But what I will say is that each of these laws establish thresholds. And if you meet one of the thresholds, then you need to comply with each individual law. So let's say if you're an online business and you have customers in California. If you have over 25 million in annual revenue, and that has been interpreted as your global revenue, or if you buy, sell, share, or receive personal information on currently over 50,000 consumers, households, or devices, you have to comply with California privacy law, even if your physical office is not in California. So 50,000 consumers, households, or devices comes down to approximately 147 consumers per day. So if you have a busy website and you receive this many visitors per day that your IT department can probably measure, then this is something that you need to be complying with. So Virginia, Colorado, and Utah have similar thresholds. And again, you need to only meet one threshold in order to have to comply with the privacy law. And the good news for nonprofits is nonprofits are usually exempted, except in Colorado. There's no specific exemption for nonprofits, but you have to, again, follow the criteria. So let's say that a business is large enough or deals with enough personal information of consumers that you do need to comply. So what does it mean? So typically you need to have a written privacy policy. For websites, you will have a privacy policy posted online. And then these laws give consumers specific rights to what they can do with their personal information. So one most important right is the right to know. I, as a consumer, can write to the business and say, I want to know everything you know about me. And the business has to comply, usually within 30 or 45 days. You need to look at the specific law. And you will need to tell them all the information you had on them for the last usually 12 months. You also have a right to correct the information in all 4 states. You have a right to request the deletion of this information. The laws also define sensitive personal information, such as, for example, social security numbers or banking information, maybe your driver's license or your precise geographical location, geolocation, which is so important for us that we want to have an additional level of protection. So you also have a limit to request that the business limit the use of sensitive personal information. Now, a lot of these requirements, incidentally, are not yet in effect. So California law is currently somewhat limited against the rights that you see on the screen currently. But as I said, effective 2013, for some laws in January, some laws late in the year, all of these rights are coming into effect. There are also additional rights that consumers have to opt in or opt out of sharing personal information or selling personal information. And the differentiation usually is whether or not that's a minor or an adult. And there are also rights to opt out from targeted advertising or profiling. So, frankly, a lot of businesses in America would not yet meet the thresholds that we discussed. So does it mean that you can be completely unaware and not pay attention to what the privacy landscape is and what the requirements are? No, unfortunately, what we see is that the privacy laws are developing. And right now we have a patchwork quilt of various laws out there that might come into effect any moment. So if this is the current landscape, a few months from now, we might have a new law that would lower the thresholds and more companies will be obligated to comply. So some of the best practices, as we're seeing this changing landscape, is you need to know what data does your business collect and why do you need it? And do you really need the data that you're collecting? So we are no longer in the age where anything goes and the more information you have on others, the better. The principle now is data minimization and transparency. So a good place to start as we're paying attention and assessing where your business is know what data you need, know what data you have, protect the data that you collected from cyber attacks, from bad people trying to take it. Consider whether or not you need to have a written privacy policy, and definitely have somebody in charge. When nobody is in charge, usually nothing gets done. And last but not the least, pay attention to the developments in the privacy space, because like we said, the regulations are developing, there are new laws coming into effect, there may be a federal law very shortly, and that can significantly expand what the current obligations are. So with that, do we have some questions about the US privacy landscape?
Jana, thank you so much for that overview. I do want to open up the opportunity for questions to the audience. So if you have any, please feel free to send them into our chat, and we can pose them to Jana and the other panelists. And as we wait for hopefully some audience questions to roll in, I have a couple for you, Jana. So you mentioned a real patchwork quilt in the US of privacy laws. And so if I operate my gallery or my business in one particular state, but I have an online or e-commerce business, how do I know which state's laws I really need to comply with?
So you need to look at, again, the thresholds for each of the states that have the privacy legislation. So let's say you have a very busy website. So let's say you are an online business selling maybe prints or multiples online, and you would meet each of the state's thresholds. So that means that you will need to have a privacy policy that's compliant with all of the 4 states. And that's interesting because some of the laws are not exactly aligned to the other privacy laws. So you can either have a single privacy policy and build a compliance procedure that would follow the most strict requirements everywhere, or you have modules that would comply with particular laws of particular jurisdictions. So you would say, this is my general privacy policy. And if you're a California resident, please also take a look at this module. If you're a European resident, please take a look at the GDPR module. So we will be jurisdiction specific dependent on where the consumer is.
Understood, and that makes perfect sense. Thank you, Jana. And you mentioned erring on the side of full disclosure and transparency, and also you mentioned the different disclosures by state, you could have in your privacy policy. Is there any downside to having a very broad privacy policy that, discloses every possible type of data, every possible type of use for it? Or is that generally recommended?
Absolutely. There is a downside for overly broad approach to using other people's data. So first of all, according to the studies, and I believe Deloitte did a study on consumer privacy and how businesses use data, consumers are much more likely, I think the statistic was 80% more likely to do business with companies that are transparent about how they use their data and that disclose their practices in their privacy policies. And if you read privacy policies and it says right then and there that I'm going to use your data whichever way I want and you don't have any control over it, I'm not so sure that I want to do business with such a company. Like, think about it. Some of, for example, storage companies fingerprint people. And then if you don't know for which purposes your fingerprints could be used, that's really scary. So as consumers start paying attention to privacy policies, I think they would be selecting who to do business with based on how sensitive the business is about their privacy. And that could actually be a competitive advantage for businesses. Are you privacy conscious or are you not?
I see. And thank you for that kind of business perspective to it too, as well, Jana. I know it might seem tempting to just make sure you disclosed every possible thing, but you do have to think about how it'll impact your business and it might scare off some consumers, in fact. So thank you for that. And we did receive one audience question. Are we seeing a trend in other states?
Tess, you got muted.
Thank you, Jana. You mentioned the variety of state privacy laws being enacted, that we might see some federal legislation on the horizon. Do you see a trend in other states enacting their own privacy legislation before we even get to that broader federal legislation?
Yes, and anyone who is interested can Google IAPP, US Privacy Legislation Tracker. They have a very handy map where they show where privacy laws are in committee, where they're being discussed, where they have recently failed, and you can see what the state of the union, so to say, is. There's also several federal privacy bills that are being considered. So right now we have state level legislation. I personally hope that we will have a federal legislation so that we can comply with one set of laws as opposed to 50 potentially.
Uniformity would be so welcomed. I hope so too. And yeah, I'm sure we'll have many more questions for you as the discussion goes on and as we have our Q&A later. But I would love to turn to Lawrence Shaw at this time to discuss ADA compliance considerations.
And Tess, I think I was going to frame the legal issues for Lawrence to discuss. Do you want me to go ahead? Or
Yes, please do.
Okay.
That'd be fantastic.
All right. So another topic we wanted to cover today is the web accessibility, and that means how do we accommodate blind, vision, or hearing impaired people or other people with disabilities when it comes to websites. So incidentally, Lawrence would be, actually, Lawrence, you're sharing the screen right now. Let me go back to my slides real quick. All right. So in terms of web accessibility, a lot of people heard about that. A lot of people think that they are compliant, but statistically, and Lawrence would cover that as well, very few companies actually are. So when we talk about web accessibility, we actually going back to Americans with Disabilities Act. Everybody is familiar with that from, again, real life. And we know that there is Title I that applies to employment, and Title III that applies to places of public accommodation. For the art business, some of the examples of places of public accommodation, again in real life, are places of exhibition or entertainment, places of public gathering, museums, libraries, galleries, and other places of public display and collection. Additionally, United States Department of Justice came out to say that ADA applies to online operations. So a website is also a place of public accommodation to which ADA applies. There are unfortunately no formal rules as far as how do you make websites accessible. DOJ has not come up or adopted any of the specific rules. So we have other laws and regulations popping up, again, the same patchwork quilt. In fact, that California privacy law that I just mentioned, it incorporates accessibility requirements into the privacy requirements. Isn't that interesting? And what they do is they reference the Web Content Accessibility Guidelines, abbreviated WCAG. There are several versions, they get updated, but the California privacy law references specifically version 2.1 of June 2018. So most of the enforcement on the web accessibility has actually been in the form of enforcement by individuals. So there are lawsuits against private companies, including a lot of lawsuits against galleries for failure to make their websites compliant. Here are some of the standards and the lingo that you would typically see in the complaints. And the standard is reasonable modifications. So what we need to make websites accessible is we need to provide reasonable modifications for people with disabilities in order to be able to take advantage of the websites and be able to enjoy them the same way as able people would. So some of the laws that, some of the case law that we see coming out has not been uniform. So First, Second, and Seventh Department have held that websites can be places of public accommodations. But some circuits disagree. So I won't get into the details of the cases, but you would be able to look that up in your materials if you are interested in the particulars. So New York district courts have actually begun to question whether or not websites should be places of public accommodation. So here you have some of the cases also. So if a website is a place of public accommodation, what do we need to do? The website has to be operable, understandable by individuals with disabilities, and the site has to be compatible with the tools that the individual with disabilities would use in order to be able to interact with the website. So it might have, for example, a screen reader that would tell you what is written on the website, or if there's an image, a screen reader needs to be able to interact with an image and tell a person with vision impairity what the image depicts. So the information, most importantly, has to be perceivable to individuals with disabilities. So some of the reasons why you need to become compliant and be aware of ADA web accessibility principles. Number one, it's the right thing to do. And let me just pause here, because I think that in this day and age, nobody wants to discriminate against people. And when a website is not compliant, that's essentially what is being done. The other thing is legal liability. A lot of litigation that we see is expensive. There are fee awards, there are injunctions, there are sometimes punitive damages if an infringer is a repeat offender. And most importantly, it takes away from the business, and nobody likes being in litigation. So there is a very real cost for not paying attention to this particular issue. In addition, if you have repeat litigation, you incur the cost to your reputation. So some people might say, well, I don't know how to become compliant, but if I get sued, it's not that expensive maybe. Well, the costs are mounting, and while one particular lawsuit might not seem like a big deal sometimes for clients, repeat claims are now exceeding over 100,000 in damages. This litigation has been multiplying in recent years, and I included for you here some of the recent headlines. So just earlier this year, a new wave of lawsuits accuses 50 art galleries of violating ADA. So in terms of the life cycle of a claim, what you would typically look at is, does your business have an insurance coverage? Because there is insurance for these sort of claims in the space, and your insurer would typically also help you and guide you on how your website should be compliant and what to do. But once you're actually defending a claim, you need to determine in which jurisdiction you are. And remember how we said that jurisdictions actually disagree if websites are places of public accommodation. So this is where it would play a role. You need to look at the decisional law of your particular jurisdiction and see what they say about websites. There could also be a statute of limitations issue. Is this claim too old? Does the person accusing you of not being compliant even have standing to complain about that? Meaning, are they the person experiencing the harm? Perhaps you already fixed your website since before the claim was asserted, and maybe the claims are moot. Then, in addition to addressing the legal issues with defending the claim, you also need to address the underlying issues of whether or not the business is compliant. So we need to assess whether or not the accommodation that's being sought is reasonable. Are there any barriers to that accommodation? And what sort of work has the business already done in order to become compliant? So with that, I will actually turn it over to Lawrence so that he can give you some practical recommendations on what ADA compliance actually means.
Thank you, Jana. I'll just share the screen. Good afternoon, everybody. Let's move on to these. Yeah, so Jana's already covered sort of this, actually putting this at the same sort of slide. Yeah, I mean, the sort of the cost of these cases, and that's just the two issues really, the cost of the cases and how you deal with it. You know, this is sort of 2019 when it's sort of reaching this sort of level. But really, I suppose the big problem now, and the sort of, I suppose, the threat that it all faces, and we'll sort of, at the end of this, you can all go and actually check any website, and we'll show you just how easy it is to find the sort of vulnerabilities and the exposure. You know, this is becoming big business. It doesn't. It's a, you know, it takes you less than a minute to understand the vulnerabilities or the exposure of a website, and it's very easy to issue demands. And as Jana said, the demands, you know, we've got sort of settlements at about sort of $8,000 starting point. There's also, you know, what you do with whether you receive a demand or you sort your website out, you've still got to sort the website out, and sort of reacting to that's expensive. But of late, this sort of new sort of wave of lawsuits have already also started introducing monitoring. So as part of a settlement, they insist you have their monitoring services, which typically can cost $9,000 a year. So this is, you know, claims are already approaching over $20,000, and people say, well, actually, this is minor. We don't know a lot about this. We haven't heard a lot about it. But not many people really want to talk about being sued for discrimination. And, you know, there was some surveys done. We haven't got sort of it updated since, but, you know, in 2020, this is already estimated to cost 600 million a month. So that's, you know, over 6.6 billion a year. You know, it's a considerable risk. I mean, most people insure against cyber, but the average cyber claim is only 10% go above $5,000. This really is sort of quite an issue now. So I suppose the question we always ask are where do people sit within this? Because the sort of people are within sort of three categories. There's, you know, just under 40% think they've dealt with it. Just over 40% are, in quotes, dealing with it. And then you've got about 20%, 19% who actually don't know about this. The big vulnerability is really the people that who believe they've dealt with it. Because there's lots of talk and lots of discussion. Oh, we've dealt with this. We've got an overlay. We've been promised by the supplier, which we'll go through as the keys. But that's the heart of the problem: is thinking it's okay. You know, believing you've dealt with this when, you know, the data Jana showed earlier and sort of the research we've just finished. You know, and you've got, you know, the WebAIM Million survey. There's a company called SiteMoz we've got. Any subject will tell you it's between 95 and 98% of websites are basically immediately, and this is just down to the homepage. We've looked at a range of the sort of the art sector websites, and there's something like 97% failure on the first page. You know, in higher ed, we surveyed every higher ed, so 89%, and this was just looking at the home. So this is how prevalent and how easy. And this is where the sort of risk lies today. And when you say you've dealt with it, and I suppose this is where the key issue is today for a lot of people, is this sort of underlying false sense of security, and I'll cover why. But, you know, you've got the vendors that sort of go into this. You know, yes, everything's okay. Yes, you know, yes, you will always be compliant with our system. There's probably what's happened in the last couple of years, things called overlays, widgets, where, oh, put this on your website, you know, you'll be perfect. Things that people think doesn't apply to them. But also, you know, they've dealt with it once. Your website it's not like with physical accommodation, you know, wheelchair ramp, yes, it's made of concrete, it's done to specification, you know, it may get inspected every 5, 10 years. It doesn't tend to sort of fade, go away or break, or it might do, but you'd notice that. The thing is with a website, it's a thing of continual change, and the regulations are evolving. The technology behind the scenes, this isn't a one-time fix. Now, when we look at vendors, you know, we look at, you know, this is, you know, we can do this. We work in various sectors, and, you know, presenting yesterday in restaurants, there's big players in the restaurant industry. You know, they've got, you know, this is one of the names we found, and, you know, we'll do a rankings on various suppliers and vendors who offer, you know, this Exhibit E, a website company. You know, they make the statement on their website. It says quite clear, and this was taken from their website today, just to make sure it's up to date, as it says there. As of November, our sites meet the standard. Okay, absolute, you know, and that's taken from their site. So we looked at one of their websites. In fact, we looked at 20 of their websites. No, they don't. You know, and you know, people in good faith have taken that as read, and we'll show you how you can use this. I mean, it's, you know, that website's in orange, green's good, red's bad. It needs to be a way that you can simply understand and immediately understand a level of exposure and risk. But when you're buying in good faith, and this is where Jana says, and the importance of getting good contracts in place. How do you deal with this? How we'll come on to in a moment. But the other thing is we've got this new breed of sort of, I suppose, promises of compliance, and this is taken from a website. This is the Access AI website. It says there, use our code. It's sold on a promise of compliance. Unfortunately, these little circles here are now becoming more of a target, because people think they've dealt with this. They receive a demand because these serial plaintiffs know what to look for, and they think, right, you're going to be an easy target because you think you've dealt with this. And then you try and contact the company who's made this promise, and we'll leave you to draw your own conclusions. But I think with Wilson, working with Wilson Elser, we know quite a few people in Wilson Elser who've also gone after these companies. Yes, it's not the best. And you're on your own. There's a lot of promises, but defending these matters is quite complicated. It's very technical rules, very technical regulation, and that's really at the heart of it. We talk about this WCAG, ADA. There's so many standards in this, and that's what a lot of these organisations are banking on. You don't know what you're doing. So people have made decisions on buying this technology, but using this. It's not your fault what you've done. You've done the best you can, but it's going to have to be done properly. Either do it now or wait till you get a demand. These demands are not going away. They're very easy money for people. They can sit in an office. I mean, there was a New York firm that was barred end of last year, and last month. They're issuing 700 a day. It's just let's send out some demands. In higher ed, 13% of demands get paid on receipt. That's just how common this is becoming. So how do we solve this problem? You're not going to solve this problem and remove the risk if you think of this as a technical website issue. If you continuously chase the technology, no website in the world is compliant with the compliance standard, this WCAG that everybody refers to. We can find issues with any website you could point to us. We can find failures. Even the standard itself is a failure because it conflicts in the different terms. If you start to look at this, and it may sound strange, look at it from an insurance point of view. How would you deal with insurance? That's you can't deal with the technicalities because they are too technical. But if you took an insurance approach to this, you'd probably be better placed. So it may sound strange, and it'll sort of come about hopefully in a minute. But firstly, decide on the level of cover. Do you want to be covered for this? Now, you can ask your insurance. One of the things we do, we have a quite unique policy. We work with Gallagher, is our sort of main broker. It's a policy through Lloyd's. It's the first sort of its kind. We work a huge amount with Wilson Elser and sort of supporting and protecting. But firstly, decide, do you want to be covered for this? And that's a yes or no question, because the claims are not going away. And even if your website, in quotes, was perfect today, you've got a perfect website today, what's going to happen tomorrow with human error? It's like, you don't plan on having a building fire or a flood, but you still want insurance for it. This is an ongoing thing. The next thing to do is really ensure, and I know all these promises, everybody will tell you, yes, you do this one thing once, and this isn't a one-time thing. This is an ongoing thing. You have to be able to allocate at least. It shouldn't take more than an hour a month. I mean, we'll show you with technology, not today, but our tech. You can start with, we've got some free stuff people can try and actually really find out their exposure and then monitor it. But it doesn't have to be complicated how you deal with this, and with the right technology. And then and it may seem strange to understand your exposure at the end, but if you don't understand, if you haven't got the time to deal with it, it could be an exposure or not. You need to allocate the time. That's the key thing there. And we'll show you can start off with our initial protection. We'll show you how to do that. So what we'll do in a moment, and say, this is just a sort of quick walkthrough of the screen. You can use our free service. So you enter your web address, go to our website, AAAtraq.com, enter any web address you want or enter your own. It'll then show you the results. And what we've done, we've been doing this for 18, 19 years. We've got a database of about 3.6 trillion data points, 630 million images. we got quite a lot of information, which is when we went to an insurance company, it was easy to sort of present to them to say, this is where we are. So what we've done is using lots of wonderful whizzy AI and all this tech and all this stuff we've got, you type in a web address and we've worked out how to profile risk. Look at a website. Green's good, red's bad. And the higher the number, the greater your risk. Because what you need to do as sort of, I suppose, as curators, art people, you don't want to get into the technicalities. You want that number to go down. So that's the whole point. And then you can use this service to monitor your score. So when you use the system, it'll come up with a pop-up, and then it'll ask you some basic details. You don't throw into any information before that. Okay. Now let's sort of show you. So that really, quick look at where we are. I mean, I'm not, we do a whole range of services. Say we do insurance, we do the sort of process behind how you're getting insurance, but we're not really going to sort of look at all this today. So let's really, oops, go on that screen. Click the audit button, right, the fun part, here we go. How can you go and look at any website? How can you get to the detail of compliance without actually any knowledge or any experience? So you go to our website, key in a website address, click the audit. Now, yes, I ran that one before, but it'll take you between 30 seconds and a minute. And that, as you see, that was the site that came up. Say green's good, red's bad. Now, this is actually a provider of one of these so-called overlays. And as sort of Jana mentioned, there are some things that you can all do to your website, and you can all do, and you should be able to do yourselves. It's a subject of its own right, is talking about describing images. It's a whole area for this market is, the laws are there. But one of the things, if you want to drill into some detail about this, but not have to deal with the technicalities. So you can type in a web address and then you click the show yours button on this thing, because there are three things that these serial plaintiffs, these drive-by lawyers go after. They tend to look at images. So if you've got a picture on your website, what you need to do is you give it a description. There's some, Jana and sort of Maria can share some great links that we've got, which start to talk about how to effectively describe art online. It is a very complex, it's one of the most complex subjects you'll deal with. But so the three areas that you need to look at is really the images. So that's where you've got pictures on your pages, because somebody who's blind has some technology called a screen reader. And what it does, it reads out the description, what they call the alt text for the image. Now, there are 7 checkpoints when you look at the technical standard, but let's try and humanize it. It's about having a description that somebody can understand. And this actually is showing for real what these sort of overlays, these widgets, these promise of compliance with this. I think we're one of the only technologies that can do it. So it'll tell you what the alternative text. So if you put your website in, you click the show yours, and it will show you what the text description is you've got for the image. But what we can also do with where somebody's got with these overlays, these things that are supposed to deliver compliance automatically, we can interact with that and look at what it's done. And this is running it real. You can try it yourself. So that's the company's logo, and that's what that AI engine. I mean, I'm from England. Yeah, I type fast, and we talk very quickly, and our emails are not always that good to understand. We have spelling errors, but not even I could write. Not even I could type in a random set of characters. So and this is real. We didn't make this up. The next thing to look at, and what that should probably say, is Access AI's logo. That would be a good description to describe it, not location, percentage, because that text there is what the screen reading technology that a blind person would actually read out, which might be quite difficult to actually interpret that as the company logo. I mean, accessibility, comma, shift, comma, K, alt, control, full stop, computer key and keyboard. I don't think it's the best description for that image personally, but hey, computers do their own thing. But so the other 2 areas to think about are images. Then you've got forms. So where you've got a box on your website where you type something in, that's a form. Now, if you couldn't see the description for the form, you can't fill it out. Same for a blind person. So they have to be labeled. And then links. The other thing you have to do is a link. If you think of it from a blind person's point of view, and also people paging around a website, a link's the navigation. If you describe the link 3 times in the same way, it's like having a road sign pointing 3 directions. That's what I mean. These rules and these rules and these requirements are not that difficult to follow if somebody takes away all the technicalities. That's what we're about. We're about, so try your website, but do think of this as sort of don't be frightened of it. Think of how you deal with insurance. Think of how you deal with general business. Don't move away from the technicalities of it, because that's, unless you are technically qualified, you'll always be chasing the technicalities. Where you buy, if the first thing to do, are you insured against this? Yes or no. If you're not insured, come and talk to us. If you've got suppliers making promises, go and talk to Jana. Ask them for an indemnity. Right, you've promised we're compliant. What happens if we get sued? You indemnify us. And then go and put a website. Try that system, AAAtraq.com. And if you want to go into more details, it's there. And if you want the monitoring, go and use it. Try it. I'll summarize there because we're sort of moving on. Over to yourselves.
Lawrence, thank you so much. That was fascinating. And even with your incredibly thorough explanations, I still have a billion questions for you.
You said 2 questions. There are only 2 questions.
But I absolutely want to come back to those after we turn to our intellectual property-based discussions. I have a feeling my questions and some of the audience's questions might tend to overlap with all of these fields, and it'd be great to get a full overview of everything. So I'd love to turn it over to Irina now to guide us in our intellectual property discussion.
Thank you, Tess. And thank you very much to Jana and to Lawrence for setting the stage and discussing these very important and difficult topics in such a thorough manner. I have been taking copious notes, so thank you so much. Let me start with my presentation. I hope you can see the slides on your screen. All right, legal issues for galleries. There are many, many, including copyright and intellectual property. Before really knowing where we stand, we have to figure out if galleries are operating with primary market players or with secondary market players. So depending on where you stand, some things might be duplicative and some things might be unique to your clients and your circumstances. I am presently acting Director of Legal Affairs at the Artists' Rights Society, an organization that works with many, many artists on their copyright needs. And galleries that work with living artists have to take certain questions into consideration. For living or recently deceased artists, copyright is a big, big concern. For galleries dealing in old masters' works, not so much. All right, and as for the Center for Art Law, we are an educational institution. So maybe copyright issues look different from this vantage point. As Minelli mentioned, there is a new clinic that we're looking to introduce on artist-dealer relationships. Again, this is squarely in the subject of what galleries need to know, and of course, what artists need to know. So what comes to your minds when you first think about running a gallery? Who are your clients? Where is your stock coming from? And how do you not go out of business? Having good compliance definitely is going to keep you afloat longer, but having good relations with your sources is quite important. So for the primary market actors, having contracts with artists on different matters, on how you split proceeds and how you manage copyrights is of concern. And then I decided to share with you these in the slide. How do you promote your exhibitions? Well, galleries increasingly can't do it alone, so they turn to third-party service providers. And sometimes these third-party service providers are happy to keep information about exhibitions on their websites without removing the content when the exhibition is over, when the relationship between the gallery and the artist is no longer in force. So these pieces that are lingering on the internet primarily are potentially leading to copyright infringements. And it's important to think of where content comes from, where it is kept, and how long it's there, and then when it needs to be removed. It's not necessarily for the galleries always to archive their materials. There are other Wayback Machine services and others that are archiving contents, but for business purposes, using copyright of somebody else is a big concern and it should not be abused. So when you think about galleries, when I think about galleries, probably the best known one in the world is the Gagosian Gallery. And they represent a big roster of living artists, including Richard Prince, who has had a few run-ins with copyright law because he and many others like him are using works of other artists in their body of works. So what kind of a relationship does Gagosian and Richard Prince, what kind of relationship do they have? There are lots of considerations, and we should expect that copyright is one of them. Let's see if I can take you on a field trip to the Gagosian's website. You should be seeing their terms and conditions page now. And it's very educational. It's very smart because, again, Gagosian is one of the leaders, if not the leader, in the field of primary art market participation. They have a very detailed terms and conditions page. They also, just for your FYI, they have a privacy policy, information about submissions, cookies policy, as Jana mentioned, and website accessibility. And I did a little bit of due diligence during the presentation. I ran their website through AAAtraq, and they have pretty good score. Not perfect, but they are doing pretty well. So they inform the user of their website. We don't always get to walk into their space in person, but they inform the users of copyrights. They inform the user of license, if any, and none that is granted to those who enter the space. Back to our presentation, though. So what are the bases for protecting copyright that artists and their heirs have? Very quick review of the copyright history. US Constitution makes a brief reference to the powers of regulating or securing for limited time to authors and inventors the use of their respective writings and discoveries. Visual artists are welcomed, if not named, in this rubric. And this limited time, as many of you know, keeps expanding. It's not indefinite, but it is long. So if you are not representing, let's say, a deceased artist, but that artist's copyright is still alive and well, there needs to be permission, unless a certain exception is in order. And then from the copyright, from the Constitution, a big Copyright Act, the most recent version of it is 1976, flows out. There are many sections, from very basic on definition and what is covered to what kind of damages infringers can expect to pay. And their exclusive rights to the artists. I'm sure many of you have heard of these exclusive rights. They include reproduction of the copyrighted works and the right to prepare derivative works. When a catalog is printed, for example, it is a derivative work. When a t-shirt is printed, it is definitely a derivative work. And there are many other manifestations. When an NFT is made, there's no law on this subject matter, but I'm of the mind that a derivative is made. So if a work is protected by Copyright Act, derivatives need to be either cleared with the copyright holder, explained away, or for those who are very risk happy, they can just sit and wait for a shoe to drop. So there are limitations on the exclusive rights. We have seen a number of cases play out in court. We are very eager to see how the Supreme Court will handle the dispute between Andy Warhol Foundation and Lynn Goldsmith about a use of a copyright protected photograph. But there are limitations on exclusive rights that are for certain purposes, for criticism, comment, news reporting, and teaching. And this is why we can show you a lot of images in our program, because it's for educational purposes. When the court has to analyze, and when you hear this, when the court has to analyze, it means you are in court. It means you have spent a lot of time and a lot of resources to be able to say, God forbid, if you're accused of infringing, to say, yes, but I could do this because it's an expensive way of ensuring that you can continue using somebody else's works. And it's probably better to handle this matter outside of courts through contracts in a more clean and less adversarial fashion. So when the court has to decide if there is infringement, they need to go through this analysis of looking at the purpose and character of the use, the nature of the copyrighted work, how original or not it is, the amount and substantiality of the amount, the portion used, and then the effect on the potential market. It's an interesting exercise, but it is a painful exercise. So we're here to encourage you to be spectators rather than participants in copyright infringement cases. All right, and then there are other regulations and rights to be reconciled. One of the regulations I'm very fond of is the artist-art merchant relationships section of the New York Consolidated Laws, Arts and Cultural Affairs Law. It explains how artists and dealers should be acting. And it suggests that a relationship that is formed between artist and dealer for the galleries that are engaged in this kind of business, they should have a consignment agreement. And I suggest that consignment agreement should spell out how the copyright is distributed. Typically, artist maintains the copyright. Usually, artist grants limited license to the gallery to display their works, to reproduce their works for marketing purposes. And usually, that limited license ends when the relationship between the gallery and the artist ends. This is a case that almost 10 years old now, but it's still quite relevant, out of the Second Circuit, Carey versus Prince, where what we expect the general public to know is that it's one artist suing another artist for copyright infringement. But I'm showing you the entire title of the work, of the case, to remind you that here the artist, Patrick Carey, is suing or sued Richard Prince, the artist, and his gallery, Gagosian Gallery, for copyright infringement. Patrick Carey accused Gagosian Gallery, among other things, of contributory copyright infringement. So for legal issues for galleries, those of you who are aspiring to be in the business or are in the business, you probably don't want to be a named co-defendant for contributory negligence. And then when Richard Prince received his works back, the case lasted quite a long time. It was very expensive, very painful, very interesting to observe. But when Richard Prince got his works back, he said he should have been sued for making, well, you can read on the screen the kind of works he believed he made for the Canal Zone series. Gallery, the Gagosian Gallery, did put up the works back on display, but query how the relationship between the dealer and the artist were affected by that case.
Real quick, for everybody that's here seeking
Yes.
CLE credit, there will be a poll that is launching on the screen right at this very moment. If you are seeking CLE, you need to ID the code. The code is as follows: 45Y9. I'll say this a few more times: 45Y9. And one last final time: 45Y9. After Irina has finished her last couple of slides, we'll be going into Q&A. If you need to leave, we 100% understand, but we hope that you're able to stay for a little bit of time for Q&A with our speakers. Again, one last final time, the code for the CLE is 45Y9. All right, thank you so much. Irina, you can go ahead.
Thank you. Did you see the code on the screen, or did I jump through it? Okay. Thank you, Minelli. All right, I know that the time is running very short, so we are looking forward to your questions if you have questions after the program. And again, this subject of what should galleries be doing, at least in the primary market space, is going to be developed further by the center's new clinic. So we invite both your participation as volunteers and your participation as critics, and any questions will be included. Thank you very much.
Thank you all so much, Irina, Jana, and Lawrence. This has been fascinating, and I especially appreciate you all agreeing to stay on for a few extra minutes for some questions. I'm definitely looking in our chat right now to see if we have any audience member questions. But in the meantime, I have a really pressing one that I'd love to get Irina's thoughts on. Your discussion of the Prince case really got me thinking. Have you ever seen or heard of a gallery getting any kind of representations and warranties and corresponding indemnities from the artist that their work doesn't infringe any third party's IP rights? Or is that just completely out of line?
It's certainly something that galleries can ask for. And if the artist agrees, then they have a valid contract.
Interesting. So definitely something to consider, but would you say it's market or kind of a tall ask for a gallery to make?
Does not sound like a tall ask to me.
Interesting. Thank you. And say I've taken all of your advice for covering my bases, securing all of the necessary consents. Should I also include, perhaps in my terms of use on my website, some terms that govern my users' interactions with the art and IP on my website, to make sure that they're not copying, printing, reproducing in any ways the artist's works? Is that incumbent upon me?
As a gallery?
As a gallery website operator, yes. Or as a gallery, yes.
We can open this to both Jana and myself, but yes, the terms and conditions of galleries' websites, and unfortunately, we're speaking a lot about the digital interaction between galleries as businesses and visitors as their clients. The terms and conditions do state what kind of uses are permissible and what kind of uses are not permissible. For example, scraping of the websites usually is not permissible and clearly stated in the terms and conditions.
Yes, you absolutely should have terms and conditions on your website whenever you have a customer-facing website. What terms and conditions do for you is the same thing that your contract does for you. It's an opportunity to protect yourself. It's an opportunity to limit liability. It's an opportunity, for example, to shorten the statute of limitations should things go south. It's an opportunity to limit the amount of exposure you can have from statements that other people make, from, let's say you have content creators that post content on your website. You want to limit your own liability for these things, especially when you don't monitor and control absolutely everything that's being posted. This is an opportunity to also clarify to the users how you expect your website to be used. And if you have different categories of users, you also lay that out. So it's an excellent opportunity to, again, make your life as safe as possible online.
Those are all definitely very key considerations for galleries, art businesses, and any business really operating in the digital space. I want to give our audience another moment or two to ask any questions. We really welcome them. Probably had enough from me, but I do have a couple more. This one might span Jana and Lawrence's expertise. If I receive a complaint that my website is inaccessible, whether an email, legal letter, or an actual filed complaint, will me making some really prompt upgrades to my website resolve the issue, or has the damage already been done that an individual was unable to access my website when they tried?
Well, to the extent it's a legal issue, I'll address that. So you actually have two problems to address. First of all, your website may or may not be compliant, in which case you'll need to check with Lawrence and you need to actually look into what is being said about your website. So do you have alt text, and does it make sense? Do you have contrast issues or not? How are the forms doing? How are the links doing? You need to double check all of that. So the complaint might be very specific, or it might be very basic, as a lot of complaints are. So sometimes you need to do additional homework on that. But the second part is if you have a demand letter, you respond to the demand letter. You can't ignore it. If you have a complaint, that means you need to appear in court and defend yourself. Otherwise, a default can be entered, and nobody wants that. So you cannot ignore it. But every time you get something like this, a good practice would be to pick up the phone or have your attorney pick up the phone, call up the opposing side and say, well, what are you claiming the issues are with the website? And maybe you can have a discussion and have an early resolution. So typically what the opposing side would look for, besides a monetary settlement, is a reasonable accommodation and changes to your website. So ask what changes are they expecting you to make? And perhaps if you already have those features on the website, this entire issue would be a lot easier to resolve than if you don't have them.
Thank you, Jana. That is really helpful to know. And I don't see any audience questions. I just have one final, might not even be a question, just kind of food for thought for us all as we move forward. I know both Jana and Lawrence really emphasized the importance of having thorough textual descriptions on the websites, and particularly for galleries and art businesses, moving their business online, having images of the works. How can I go about getting descriptions of the artwork featured? Can my curators and I come up with those descriptions? Can my artists object if they're displeased with how I've kind of characterized their works? Do you foresee any moral rights implications down the line there with galleries coming up with their own descriptions of the artist's work?
That's actually a very interesting question, and I don't think that there's any guidance as far as what content you have to put in there. And certainly the art market is exceptionally adept about writing curatorial texts describing artworks. But we have some specific challenges when it comes to alt text and the art world. It is easier, probably, to describe figurative works. So you can describe, you have an oil painting with a man and a woman in certain attire, man holding a pitchfork, and you can have a description that everybody would agree with. But actually, this was an interesting exercise that the Metropolitan Museum of Art engaged in. They had 3 different curators describe a sculpture, and they came up with completely different descriptions of what they were seeing. So describe what you see is not always that apparent. But let's take abstract art, let's take conceptual art. What do you say in that description? If you describe what you see, you can have very, very different descriptions. So perhaps in the art world, and this is my suggestion, that's not a standard, we can have some creative way to allow disabled people to appreciate artworks. And in preparing to today's presentation, actually, I looked up that the Massillon Museum had a very interesting way of allowing disabled people participate with their abstract artworks. So they had 10 abstract paintings made accessible, and what they did is they included large type and braille artwork labels, and was produced by Clover Nook Center for the Blind and Visually Impaired. They had a tactile model of an artwork created by artist David McDowell, and an iPad app with headphones to explore the painting through multiple senses. So I thought it was exceptionally cool. It's not something that is required by law, nor I think it would be dangerous to try and set forth these requirements. But wouldn't that also be an opportunity for creatives to express themselves and also reach that very large portion of the world's population that is disabled, that cannot currently appreciate visual artworks?
Well, even though this is kind of a burgeoning issue and field, I'm amazed at how many creative ways providers have already come up with to ensure that differently abled persons can still interact with and really appreciate and enjoy the art that they're featuring. So I see we're quite over time, but I so appreciate all of our panelists staying to continue the discussion. Really appreciate all of our attendees joining. And this has been fascinating for me, and I hope you'll all continue to support the center so that we can continue to have these exciting events. Thank you all for being here, and I'll turn it back to Minelli for some final thoughts.
Awesome. Thank you so much, Tess, and thank you so much to our speakers. This was an absolutely wonderful discussion. We are so thankful for your time and your expertise. For those of you in the audience that had questions that weren't able to get answered, the handouts are going to be going out via email to everybody that will have the contact information of our speakers if you have any other burning questions that you really want to reach out with. In the meantime, thank you all so much. Another great thank you to our speakers, Wilson Elser, for hosting this event with us. And if you enjoyed the event and want to support the Center for Art Law, I really encourage you to donate and help us put on more programming like this for the future. Thank you all so much, and I hope you have a lovely rest of your day.